Just before you start, Ms. Ward, just to say this is not a day on which we can sit late. I don't think that'll be a difficulty for anyone, but I'll tell you now rather than at 4:15 when you're thinking, well, we can sit a bit longer. We can sit a bit longer than 4:15, but not much. Right.
I'm grateful, my lords. I should say you've, I think, got an additional authority handed up, not from me, but it's
not your fault.
Just to flag that it's there. Not my fault either. I think it's come from Mr. Blundell and Ms. Smythe, and it will be addressed.
No, that's fine. No problem.
My lords, as promised then, 3, I hope, brief points. Firstly, to address the ongoing issue of implementation of the Withdrawal Agreement via Appendix EU. So what actually this case is concerned with beyond the bare facts of the appellant's case. That's a short one, but you've not actually been shown what is at issue now in any case other than this, and it is in my submission important for you to see that. And it also goes to why the IMA is concerned.
I haven't understood what you're saying. Well, what do you mean by the ongoing issue of the implementation of...
So the ongoing... So I've attempted to summarise too summarily, I think. I'm going to show your lordships the current iteration of Appendix EU as it applies the dependency requirement to over 21-year-olds. Because what you've been shown by Mr. Butler, and entirely rightly, because it's what was applied to his client's application for pre-settled status before the 24th of August 2020, is not the current version which would apply to people making applications now, principally those who were granted pre-settled status before the end of the transition period and now seek to apply for settled status.
Well, we'll trust you, Ms. Ward, but at the moment I don't see how that's going to help us.
Well, it's I hope a brief...
Okay, show us.
I will show you. So,
then may be clearer why it's something we need to know.
So, like I said, my 3 points would be that the remaining...
Well, don't spend time with that. Just tell us, go straight to your first point. So, my lords, this came about as a result of what was said at paragraph 8.2 of the Secretary of State's response to our intervention, which I hope your lordships have had the opportunity to read over lunch, which was effectively, there are no other cases in which, if anyone's aware of, in which this issue is arising. Right.
Now, I should say immediately that the IMA agrees with the position as set out at paragraph 21 of the Secretary of State's skirting argument, and that's for your lordship's note, page 50 of the core bundle, that Appendix EU, the current version of the immigration rules, requires a child over the age of 21 to be dependent at the date of their valid application, or where the date of the application is after the end of the transition period, at the end of the transition period. Now, what you were shown, quite rightly, because that's what applied in this case, was the rules as they applied before the end of the transition period, when the only application it was possible to make, of course, was there could be no backward-looking element to the end of the transition period. Now, as set out in our written submissions, and as I think is common ground, the effect of the withdrawal agreement is to take a snapshot at the end of the transition period in terms of who is within the personal scope under Article 10. And it may actually just be much easier, my lords, to show you what I'm talking about, and it's in the supplementary bundle at page 83. Thank you. And what you have there is the definition of child. Now, as my learned friend Mr. Butler showed you this morning, the relevance of the definition of child is that in order to qualify for any form of leave under Appendix EU, a person in the position of his client must show that they are a family member of relevant EEA national or relevant EEA citizen, and a family member includes a child. And a child is defined as A, the direct descendant under the age of 21 years, that's the first subparagraph, and then B, 1, the direct descendant aged 21 years or over.
Sorry, I like to let advocates take their own course, but at the moment I've got no clue what are we talking about. Tell me what your point is, and then you can show us how we get there.
Well, the short point, and I'll move on very shortly, is that the immigration rules now will require anyone who was granted pre-settled status between the introduction of Appendix EU and the end of the transition period on the basis that they were a dependent child over the age of 21.
To do what?
To show when they apply to upgrade to settled status, indefinite leave, that they continued to satisfy the requirement of dependency, which you've been shown by Mr. Butler, the way that appears in the rules, as at the end of the transition period.
So is what you're saying that when the Secretary of State says there aren't any other cases, there may not be any other cases just like this one, but the same issue will arise under the new rules because of what you've just said?
Yes.
Good, okay.
Exactly that, my lord. That's the ongoing issue there. There's that backward. And just for completeness, you'll see in that definition that in B2 of the definition, an applicant who is granted limited leave to enter or remain as a child on the basis that subparagraph A above applied does not have to show that they were dependent at the end of the transition period. So,
well, you see, we don't want in our judgment to deal with anything we don't need to deal with. Will it be enough for your purposes if there was a sentence in the judgment somewhere which said that although this may or may not, assuming we're satisfied that this is the case, that there are no other cases precisely like this in the pipeline, the point may continue to have significance having regard to the new definition of the child, the definition of the child in its current form for people who are transitioning from EUSS, pre-EUS to, from pre-settled status to settled status.
Yes. So,
good. Okay.
For that cohort, yes, and just one other.
I'm sorry, just before you that, isn't it enough to just assume that if the appeal is allowed, the Secretary of State would have to draw the consequences of that for the new version?
Yes.
And that would then be a matter for the Secretary of State to take into account to see whether or not it then requires change in the light of the judgment.
And, well, absolutely. And that was just the second point I wanted to make in relation to that, was to draw your Lordship's attention to the way in which there was already a carve-out for those who were under 21 when granted pre-settled status.
Well, so we will not want to write any about this. We will just want to, I agree, it will be helpful if we draw attention to the fact that whatever we decide, if we allow the appeal, may have effect in this particular situation, and just leave it to other people to draw the conclusion.
Well, that was the only point I wanted to make in relation to that. So moving on then to my second topic,
yes,
which is one that your Lordships have asked about, and so I hope I'm on rather firmer ground and something you will find of assistance, are two remaining points in relation to the withdrawal agreement. My learned friend Mr. Butler took you through it by reference to our written submissions, and very grateful to him for that, and I won't repeat it. There are two provisions to draw your attention to. Article 158, about which you asked, I think, all members of the Constitution questions, and also Article 4.1. I think my learned friend took you to most of Article 4, but not Article 4.1. So if we could start there on page 110 of the authorities bundle. I'm afraid I'm working electronically, so I have page numbers rather than tabs, but if it would help to have tabs, I can...
Page 110, yeah, but page 110.
So Article 4, And it's just to draw the court's attention to, firstly, Article 4.1, which is that the...
Yep, we've read that.
Yep.
And what's the particular
same
point you
legal
draw from
effect.
that?
So that's the reciprocity point, and that was addressed by this court, by my Lord Justice Green, in fact, in AT, which is in the authorities bundle, and the relevant reference is paragraph 85, page 482 of the authorities bundle, and also in slightly more detail.
Which paragraph?
Paragraph 85.
And sorry, again, it would just help me where. Obviously, this says what it says, and obviously, it's important in some circumstances. What's its relevance now?
Well, it's relevant in two ways. Firstly, my lords have asked about Article 158, and when they come on to make their submissions on Article 158, the importance or the requirement to have regard to the need for reciprocity across member states of the EU and in this country feeds into that, the consideration of references and what to do with them.
The importance of legal certainty across the board.
Yes.
Citizens of the UK here abroad and citizens from abroad coming here.
Yes, and secondly, quite independent of the reference point, it's also relevant to the points that I will make on what we've described in our written submissions as a developing trend in the case law of the CJEU, for this court to have regard to the likely approach in member states of the EU in order to satisfy the principle of reciprocity. I will simply give my lords the references to the relevant passages in AT. In the upper I've already given you the Court of Appeal. In the upper tribunal, it's pages 443 to 444, paragraphs 108 to 110, in which the submissions of Mr. Demetriou made on behalf of the IMA were accepted. Now, turning then to Article 158, which is on page 128. The first question the court asked was about the circumstances in which a reference ought to be made. Now, so far as any of us in court are aware, and I think someone in court would be aware if this was not the case, there is no case law bearing on this, bearing on that question. There is a difference between Article 158 and Article 267. There are many fairly obvious differences, but Article 158 is a discretion to refer. This court, any court, may refer.
Yeah, so is what you're saying that Article 267, as we thought, makes reference mandatory from the top court?
Well, there's no. Sorry, I didn't get Article 26.
I'm sorry if I'm appearing to rush you, but
No,
on the other hand,
I understand.
You're here slightly on sufferance, and Mr. Blundell's got a lot of matters to deal with, so we can be quick.
Well, Article 267, it's in very similar language on that point. May, if it considers.
Do you have the text of 267?
Yes.
Have you got it for us?
I'm sorry.
Okay.
It's just drafted in discretionary terms.
It's drafted in discretionary terms, but now where this is going is.
Folio and Novella says that final courts have to refer, but other courts have a discretion.
Yeah. And my lord, the point of distinction here is that in Article 158, so in relation to reference, there is no incorporation of 267 in 158. And therefore, my lords, I think it was my Lord Justice Green who suggested this morning that case law on when one ought to refer under 267 may be relevant to this question. That's not on the face of Article 158 the case in relation to whether you should refer, but in relation to the affect the legal effect of a decision of the court on such a reference, Article 1582 does make reference to Article 267. So the legal effects in the United Kingdom of such preliminary rulings shall be the same.
Yes. But that's after, if we make a reference,
Yes.
then the legal effect at the end of that process is the same as it would be if a German court made a reference. That's how I understand it. But I don't think that tells us anything about the circumstances in which we ought to consider.
No, well, it doesn't. As I was
and speaking for myself only, I think that some significance may have to be attached to the fact that the UK left the EU.
Yes. Well, it's absolutely. I apologise if I'm rushing the 2 points together. I understood 2 questions to have been asked in relation to 158. Firstly, when should you refer? And is there any case law on that? Secondly, what is the effect if you do?
No, I don't think any of us asked the second question.
I think on this side of the bench, we'd understood that to be the case and had some discussion about it.
Yeah, perhaps we did, but
Well, your answer is very helpful on that.
Yes.
So,
But it's the former question.
on the former question, the only submission I have to make is that, yes, of course, my Lord is right that the fact that the UK has left the EU is a factor. Equally, so is the requirement in Article 4.1 to look for consistency of interpretation of the withdrawal agreement across the EU. And if there's a point on which it is genuinely unclear to this court how it will be interpreted across the EU, then that is also a relevant factor in considering whether to make a reference. So, turning then to my...
So I thought those were, you said you had 3 points.
Yes. So 1 point was on Appendix EU, second point on the withdrawal agreement, third and final point is what I say are the pointers to what the CJEU would decide were this issue to come
Okay,
forward.
that sounds like 4 points to me, but sorry. Okay, can we have them quickly, please?
Very quickly, my lords. You have my own friend's compelling submissions on Reyes and GV, and we've described that in our written submissions of paragraph 28 as a direction of travel of the court. We've also provided you, my own friend took you to the Commission guidance. We've also provided some academic commentary that's referred to in our skeleton at paragraph 27.3, and the material there is at tab 28 of the authorities bundle, and 27.5, the material is at tab 29. It's sidelined. There is
Well, this is all in the written submission.
Yes.
Yeah.
Thirdly, under this topic, a smaller point, but in response to what the Secretary of State's submission at paragraph 23 of their skeleton argument about not taking an expansive approach to Article 2.2 of the directive, the reference there is to the case of SM Algeria, and in fact, at paragraph 53 of that judgment, and the reference is page 410 of the authorities bundle, the direct opposite is said, and in our submission that's picking up on and feeding into my Lord Justice Singh's point about the purpose of these provisions and about the right or the position of a migrant worker living with their family as a form of social advantage, and what was said by the Advocate General, albeit not adopted. I absolutely
Are these all points that are to be found in your written submissions? It's just that I don't want to feel like a schoolmaster, but I am worried for the Secretary of State's submissions. You said you'd be a quarter of an hour, it'd be 25 minutes.
Well, I hadn't realised them in 25 minutes, and I've one final point to make in that case. You have all of those points brought together. The core submission of the IMA is that what GV shows you, taken to it by my friend this morning, is that there are circumstances in which no longer needing support, and that's the terms in which the definition of dependent is rightly put, reflecting the case law in Appendix EU. There are some circumstances in which a person will no longer need support, but will nonetheless continue to be regarded as dependent. The choice facing this court is whether that is a very, as the Secretary of State seeks to portray it, a very specific situation on the GV facts under Article 7 as a form. the provisions on social assistance, or whether it is reflective of a broader principle, which my learned friend's shown you, Reyes.
As you say,
Which
we understand that's the issue.
and well, I'm going to sit down. All I say is,
I'm sorry, Miss Watt. I feel I've been unkind to you, which is not my intention, but you can see why I'm worried.
You just simply say it isn't limited to the facts; it's a broader principle.
Exactly that, my lord. And for all of the reasons set out in the IMA's written submission, that is the direction of travel of the CJEU.
Yeah.
That is the way in which the case law points on the ultimate underlying question here.
Thank you. Yes, Mr. Lamb.
My lord, I'm grateful. My lord, if this is the court, can I just outline the process I was proposing to take in terms of the format or the framework for my submissions? Proposing to take it in 3 stages, if I might. First of all, I was going to begin by identifying some key features of the facts in this case, and showing you some of the relevant documentation in that regard. Secondly, I was then going to deal with the legal framework. In doing so, I am acutely conscious of the fact, well, both of the time, but also of the fact that my learned friend, Mr. Butler, has taken you too much of the material already. So I'll try and reduce them to go through that in detail again. But there are submissions I think it would be easier to make by reference to the various materials that go through them. And then thirdly, and really falling out of that, my brief submissions, and they will be focused on the cases of Reyes and GV in particular. But before I move to that 3-part presentation, can I just begin by highlighting one general point? It's a point that's come out in argument this morning, in particular through questions from my Lord Justice Singh. This is a case about a derivative right, namely whether the appellant satisfied the conditions for a right of residence derived from the primary right of her mother, who is, of course, an EU national. The purpose of the regime of derivative rights for family members of EU nationals in EU law is, of course, based on 2 principles. The first principle is that they are dependent on the exercise of free movement rights by the primary EU citizen. So there has to be that exercise in the first place. But secondly and relatedly, they are only necessary insofar as they are required to ensure that such primary rights can in fact be exercised. And we say that mode of analysis is consistent with our approach to the issue here in principle, and indeed demonstrated by the facts of the particular case. So with that short point of principle to introduce the factual background, can I now turn to the facts? And you're obviously aware of the facts in broad terms already, but can I highlight 3 key factual issues to put in context what follows from that on the law? First, status. The appellant is, of course, a third country national, a citizen of Bangladesh. She is not, therefore, herself a citizen of the EU. That means she doesn't have directly herself any rights under the EU treaties. Any rights she has, following from my introductory points, are, and had to be, at all relevant times, parasitic derivative rights. In her case, the primary EU citizen from whom she derives those rights is, of course, her mother. Secondly, age. The appellant was 19 when she first arrived here in December 2014. At that stage, and I'll take the court to legislation in a bit more detail in a moment, she had a clear legal entitlement under EU law to enter and reside as the direct descendant relative under the age of 21. So she was caught by the first limb of the Article 22C definition, a family member in that respect in the directive. Just for your note, no need to turn it up now, but that's tab 2, page 16, because she was under 21. So at that stage, there was, of course, no need to satisfy the alternative dependency limb of the Article 22C definition. She was automatically entitled as an under 21-year-old child, and that was the basis on which she was granted a residence card on the 21st of September 2015, valid until the 21st of September 2020. However, when she came to make her application for pre-settled status on the 14th of November 2019, she was at that stage aged over 21, she was 24. So at that point, for the first time, the legal position shifts, the legal territory and background is different for her. She engages a different limb of the test and must demonstrate something different. But of course, on the appellant's analysis, it doesn't matter. She's had an entitlement to be here as a child, which then she says carries forward in the way that she's argued.
Well, hang on, did she have a right? What was her position between 21 and age 24 when she made the application for pre-settled status? I thought
So
you said she didn't have a right to be here.
Well, she had the benefit of the residence card she'd been granted as a child under 21.
Yes, but that expired.
That expired in 2020, so she applied before that expired.
Yes, I see. And what was the significance of the date on the residence card?
I think,
It's 5 years, wasn't it?
yes, it's declaratory only, so my lord will be aware of the...
Yes, I know it's declaratory only, but so if someone comes as a child,
Yes.
and dependency is effectively, well, there is no dependency requirement. They are given 5 years, irrespective of the fact their childhood may come to an end within those 5 years.
Yes. But at the stage at which...
What will be the logic of that? Why wasn't the rule simply that it came to an end when they ceased to be a child, at which point they'd have to show dependency if they wanted to stay?
Well, sorry, I can hear something behind me. I just turned my back to make sure I said the right thing before I did. So the card, the purpose of the card is to provide a snapshot of status at the time that you apply. By the time that you come to reapply, you will have to demonstrate that you were present in a lawful way at the end of the transition period. So that's why at the time, although she was making an application after the end of the transition period, she had to demonstrate that she was lawfully present at the end.
I think that's answered my question, though. Maybe this is a red herring, in which case I'll shut up and have a certain answer to it. But does everyone get a residence card for 5 years, even though there is no guarantee that they will continue to be a child or dependent throughout the 5 years? And that's simply a matter of policy.
That's simply a matter of policy.
Yes, I see.
So a different course could be taken, but it provides a degree of certainty in the meantime. You've got the residence permit. When it comes to then applying for the next stage, so here it was pre-settled status she was applying for, she has to demonstrate her entitlement to that status existed as at the end of the transition period.
Yes, I see.
And indeed, in this case, of course, on the fact she applied before the end of the transition period, so there was no issue there because the 5-year residence permit was itself coming to an end before the end of the transition period. So hers wasn't the case where the residence card spanned the transition period coming to an end.
Sorry, yes, I didn't
So,
want to pursue my red herring any further.
so in those circumstances, the next point is dependency. Now, there's no suggestion, as a matter of fact, in this case, certainly this is how we've always understood it, that the appellant is in any way dependent on her mother. And it's worth seeing how she put the position on dependency, particularly given how my learned friend has described matters this morning, in her application, or rather in her cover letter with her application for pre-settled status. You will find that in the core bundle behind tab 20. Can I just ask the court to turn that up? It's at page 185. I'm going to this to frame the submission I'm going to make about the facts by reference to what Mr. Justice Lane decided in his judgment below. So my submission did make.
So, court,
So it's core bundle, tab 20,
Tab
page
20.
185.
185.
185. It's the numbering in the middle of the page.
Yeah, I have that.
So this was a cover letter that went with the application 14th of November 2019. We'll see from the top. You'll see these solicitors say they've been instructed to deal with the appellant in her application for pre-settled status as a family member. Then if you look to the second paragraph that begins our client, explains that she was granted leave to enter the UK, and then halfway through, our client was living with her EA sponsor, her mother, an EU citizen. Our client was, and it says, and is financially and emotionally dependent on her parents, but that is not then, or is in fact explained in the rest of the letter. It proceeds in this one. On the 11th of July 2016, our client married her husband, a Bangladeshi national, living in the UK. They have a daughter. Please note our client was compelled to move from the mother's house when she married on her own choice. As they didn't take it easy, our client pretends her parents pressured her to give up her husband and move back to their house. And then you'll see the consequence of that at the bottom of the page, that they're reluctant to give any kind of access to information and documents. Over the page, some more information about the deterioration in the relationship. Our client is unable to provide her mother's passport and other documents because of her mother's unwillingness to help in this matter. She says she's been unfairly treated, shouldn't be disadvantaged. And then this. Our client believes asking her mother to provide those documents for her application in these circumstances could put her at risk of violence. Our client further states that she's been abused verbally by her parents on a couple of occasions because of her marriage. And then there's further reference there. There's a reference down the page to her having a part-time job and having her own accommodation facilities. So we say that's evidence that the relationship had completely broken down. That then leads to the refusal letter you have already seen. But just to turn back to that briefly, it's at tab 18, page 179. You'll see it's dated 24th September 2020. Halfway down the page, reasons why your application has been refused. Consider whether you meet the requirements. And then just below the second hole punch, this. You state that you're a dependent relative of a relevant EEA citizen. However, you've not provided any evidence to confirm this. The reasons are explained below. So no evidence to show that you're a dependent relative at all. It says you're a child aged over 21, but not provided any evidence in the next paragraph to demonstrate that you're dependent on the relevant EEA citizen or their spouses or partners for these purposes. And then there's an explanation of what dependence means. So having regard to your financial and social conditions or health, you cannot meet your essential living needs without financial or other material support, and so on and so forth. And then again over the page, you've not provided any evidence to show you're currently dependent on the EEA citizen, therefore you don't meet the requirements for settled status as a family member. Now, I don't need to go through the administrative review decisions that were then undertaken. They're in the bundle. Effectively the same effect. Where did that leave with the judge? Can I ask the court to turn up Mr. Justice Lane's judgment? And that's behind tab 10. It begins at page 63. My Lord, at page 64, the first page of the judgment proper, you'll see, again, level with the second hole punch, letter B, the claimant and her case. Paragraph 4 sets out basic background, and then paragraph 5 is this. It is common ground that the claimant became estranged from her mother and other biological family members, as a result of which she has lived independently from them since at least July 2016. When the claimant was aged 20. It was then the claimant married her husband, a national of Bangladesh. The claimant does not assert that after this point she was financially dependent upon her mother. So we say the judge has made a very clear finding on dependence, and he's found that actually from the point at which she left the family home in order to marry her husband in July 2016, she has lived independently. As a result of becoming estranged, she has lived independently. So the opposite of dependence. Now that's then picked up a little later in the judgment in the discussion section as well. And if the court could please turn to page 77. You'll see at letter F discussion. It's relevant, paragraph 54. It's relevant to observe that from the factual outline given above, the claimant has never been a dependent, aged 21 or above, and an EU citizen. She entered as a family member and was recognised as such as a person under the age of 21. She was estranged from her EU citizen mother since no later than the marriage in 2016. And then there's some detail given of what she said in the application for pre-settled status. There's a reference then to her working in the tax year 2017. That's 2018 when she would have been 20.
Where does that come from?
That, I think, is from some of the material she provided with the application cover letter.
We saw a witness statement this morning, which is,
Yes.
And there is a witness, yes.
But that didn't, I think, refer to her working. It's a bit confused.
So the witness statement was submitted, as I recall it, I think very shortly before the hearing. It may even have been the morning of the hearing. I forget now exactly, but shortly before the hearing. I don't think it was formally admitted, but it makes clear that she says she was working the 2015 period. So
Well, that's what puzzled me. I couldn't remember the letter. 2017, 18.
The 20,
I thought she said in the witness statement, we can look it up, we may have to look it up, that she started working the year after she arrived, which
Yes,
is
that's right, she does.
2015.
She does. So that's in paragraph 5 of the witness statement.
So that can't be the source of this statement.
No,
Right.
I think the source of this statement is in the material that's provided with the application.
Have we got those?
So you've got those, if you look at the application cover letter at page 187,
Yeah.
back behind tab 20, you'll see the enclosures, and there are pay slips.
Yes, I see.
I think.
we don't know where the judge got his conclusion from, do we?
He doesn't specify in that respect, but what he does do is draw a conclusion in paragraph 5, which then...
Sorry, one thing to just to finish this off.
Yeah.
The judge must have got that information from somewhere, and you, as who were there, should be able to tell us where he got it from. You can't have made it up.
Yes.
And you say it came from the material supplied, and you were about to take us to show that. But
So if you look then behind the same tab at page 190,
in the supplementary bundle.
no, sorry, this is in the core bundle.
Core bundle.
So,
No, it's fine.
core bundle. So this is the tab that begins with the cover
Yes,
letter.
I see.
And if you turn to the third page of the cover letter, the list of enclosures, that's page 187. And you'll see
Yes, I see.
it says bank statements, pay slips.
And what were those being submitted in order to show?
Well, they appear to be submitted to show that she was working in the year that ended 2018.
Why was that material to her application? I'm not saying it wasn't, but I just said I know.
It's not entirely clear from the application itself. And if you look at where I've taken the source of that finding and the judge's conclusions from, it's page 190. So there's a P60 end of year.
Yes, I see. Yeah, I'm sure that's right. Okay,
Yeah.
well, I won't spend much. It's just useful to have the reference.
Of course.
So I hadn't, I'm afraid. Looked at the details of this. Okay, so that's where that came from.
Yeah.
So that shows, yes, P60 from whoever the employer was, doesn't really matter.
Yeah. I don't think it's...
That's the tax year to April
Tax year
2018.
to,
So it
exactly.
covers 2017 and 2018.
Exactly.
Yeah.
That must be the source of where the judge gets that from.
Yeah, okay, thank you.
I'm not certain we can necessarily draw that conclusion because we've got a witness statement as well. I mean, we just don't know.
Well,
He
that's
hasn't
true.
rejected the witness statement.
I'm sorry?
He hasn't rejected the witness statement.
No, he's drawn no particular conclusions from it. But in a sense, nothing turns on that. What he does do is, in my submission...
He doesn't say she wasn't working before those years.
No.
He'd either overlooked her general statement, the witness statement, but it really...
In looking at what destroys the dependency relationship, though, he concludes that it's the rupture with the mother. In my submission, that is clear from paragraph 5. It's common ground that the claimant became estranged from her mother and other biological family members, as a result of which she's lived independently.
But
Well-
assume for the sake of argument that's
Yeah.
correct. Somebody whose relationship is ruptured may have to go and get work.
Yes.
So do you have to conduct a detailed analysis of the the mens rea, the mental element for why there was a lack of dependency?
Well, no, it's not that you have to conduct a detailed examination of why there was a lack of dependency, but on the facts here, it's always a factual assessment as to whether there is in fact dependency or not. And the conclusion the judge is drawing is that on the facts, there wasn't dependency, but he's not saying there wasn't dependency because she'd gone out and got work. He's drawing the conclusion. There's been no challenge to this finding.
Well,
That
it sounds to me as though there was no real focus on this issue below. There was almost no evidence on which the judge proceeded on the basis that something was common ground. It may be a little bit unclear whether what's common ground was she became estranged from her mother, or whether the common ground is said to extend to as a result of which she's lived independently, if that's a conclusion of law. This is a slightly unsatisfactory basis on which to make any finding either way.
Yes, the difficulty is I've got to meet a submission that's been made today that I should file the respondent's notice on this point.
Yeah.
Now, in my submission, we didn't have to. That conclusion is there. He does say it's common ground that she became estranged from the mother, and then he sets out what the consequence of that is. The consequence is that she's lived independently from at least July.
I don't. We've got more important things to. But
yeah,
I think I better get to the bottom of this. Are you saying it wasn't common? I mean, I did understand Mr. Butler say it wasn't common ground.
I think that must be the logical conclusion of his submission.
Well, no, I think he said explicitly something. We didn't have this paragraph in front of us, but I certainly understood him to say, I don't know how fully I noted it, that that there was no concession below.
Yes, I think that's right.
Immediately find the right moment in my notes. Mr. Butler's quickest thing is to ask you, are you saying the judge is wrong at the start of paragraph 5 to say that it was common ground that she became estranged from her mother as a result of which she's lived independently from her since at least July 2016?
I'm so sorry, my lord. I should make it clear that I don't say there's nothing wrong with paragraph 5,
okay,
the judge's judgments. But what it doesn't do is deal with the earlier period and whether dependency was lost through work, which is the point I was making.
Well, in a sense, there is something wrong. Well, depends whether, yes, I see. He doesn't say she ceased, as a result of which she ceased to be dependent. It says as a result of which she lived independently.
Yeah, but she was already living financially independently from 2015.
I see. Thank you. It's taken me a long time to get to the bottom of that.
Yeah.
So the real point, which is not resolved, is whether the judge made a finding that she was made any finding as to whether she was financially independent of her mother before she left home.
Correct. There's no finding in that respect there. But where this goes to, in a sense, is really two things. One, in terms of how my learned friend puts his case on relief today, he rightly refers back to the grounds as originally pleaded and the relief that was sought then. There's two elements that he relies on. One is, of course, quashing of the decision in this case. And two is a wider point about the legality of the EUSS, the EU settlement scheme. And it certainly, insofar as this is dealing with the specific facts of the case, that would be relevant to the factual finding necessary in order to quash. But it may have a second relevance as well, which is that if the court were otherwise contemplating making a reference, in my submission, whatever the test is for making a reference post the UK's departure from the EU, it would be relevant to consider whether there is a firm factual basis on which to do so, or whether, in fact, the reference could be determinative of the applicant's case, the appellant's case here. So in my submission, the appellant, come what may, fails on the facts. Now I accept, of course, because of the way the judge approached the issue, he went on, understandably, to deal with the issue of principle about dependence and work. I don't seek to avoid that. He's obviously dealt with it, and we're all here today to argue about that point. But that may be relevant when it comes to considering reference.
Well, thank you.
Mr. Blundell, if we leave aside the question of any possible reference,
yes,
do you accept Mr. Butler's submission this morning that there are two separate aspects to this claim for judicial review. One is a challenge to the individual decision
Yes.
in this appellant's particular case. But secondly, and separately, he submits, there is also a challenge to the compatibility of the EUSS, and that would be a generic matter.
Yes.
And on that, he says that irrespective of the particular facts, as long as the appellant has standing, and we all know that standing is a very loose concept in claims for judicial review,
Yes.
then the second part of the case can be considered, even if the first, for some reason, could not be.
I accept that. I accept that. And that's been clear from the moment the relief was pleaded.
Yes.
And he fairly took you to the relevant provisions there. But that's why I say, nonetheless, the point does have some relevance. It has relevance to the first of those points, to the factual position in the individual case and the issue of quashing.
Yes.
But secondly, and wrapped up perhaps with the point my Lord makes about one can't forget this is post-Brexit, that is a relevant fact to take into account in whether to make a reference, if the court got to that stage.
I understand it.
I'm grateful. So I hope that's clear in terms of our position on that point that Marlon raises. So, Marlon, that's what I wanted to raise about the facts. Can I then move to the legal framework? And again, I'm conscious that you've seen some of this already. I will try and minimise what I go to, but I do need the court to see some of it in order for me to make submissions. I begin with the directive. That's behind tab 2 of the authorities bundle. You've obviously seen the definitions provision already in Article 2. The relevant provision, of course, is at page 16, Article 2.2c. Family members means C, the direct descendants under the age of 21, or are dependents, and those are the spouse or partners defined in point B. My learned friends, taking you through the different rights of residence, you've obviously got in Chapter 3, page 20, the Article 6 initial right of residence up to 3 months, without formalities, bar the provisions of identity card or passport. Then you've got the right of residence in issue here, Article 7, right of residence for more than 3 months. All union citizens shall have the right of residence on the territory of another member state for a period longer than 3 months if they, and then of course it's A that's relevant to the appellant's mother's position of workers or self-employed. D is the family member provision accompanying or joining a union citizen who satisfies the conditions referred to in points A, B or C. And then the right of residence provided for in 1 shall extend to family members who are not nationals of a member state accompanying or joining the union citizen in the host member state, provided that the union citizen satisfies those conditions. That's, and of course, the final right of residence then, the novelty, at least in generic terms, of the Citizens Directive, is the Article 16 right of permanent residence. Just for the court's note, that's at page 33.
Sorry, you said you wouldn't just take it. So far, are you making any particular points?
I'm going to come back to Article 7 in a moment and Article 2 as well, if I can do that. But just to complete the suite, there's Article 16, which is the right of permanent residence. Well, just going back to Article 7, having provided that suite, paragraph 2, page 22, extends the right, as I've indicated, to non-EU family members accompanying or joining. There are, in substance, we say, 3 requirements for a family member relying on a right of residence to satisfy. First of all, they must actually be or continue to be a family member. Secondly, they must accompany or join the EU citizen. And thirdly, the EU citizen has to reside in accordance with EU law. So that means, in turn, that if they no longer...
Where's the third one?
So the third one is the consequence of 7D, a family member is accompanying or joining a union citizen who satisfies the conditions referred to in A, B or C. That was my...
I see, so that's your shorthand.
That's my shorthand for A, B, exactly. And that's, of course, workers, self-employed, sufficient resources, or the private and public education comprehensive sickness insurance provisions.
Yep.
So clear, that's the clear source of the derivative right of residence for the third country national family member. There is some case law which just summarises quite neatly what is required in those circumstances and the purpose of the provision of a derivative right of residence in those circumstances. That is the Singh case. I think you've heard reference to that. Can I take you to it? It's behind tab 15 of the bundle. I can just take the facts from the head notes. Each applicant will see was a third country national married to a European Union citizen residing or working in Ireland and was therefore a family member to whom Article 7 applied. Then just a couple of lines above letter G. The Union citizens each had periods of unemployment. The applicants each supported their families for short periods. In each case, the Union citizen concerned left Ireland to settle in another member state before the relevant residence period expired, while the applicant remained in Ireland. So the EU citizen moved outside Ireland, but the third country national remained. And the marriage ended in divorce. Thereafter, each applicant applied to the Irish minister for retention of permission under Article 13 of the directive, under which divorce did not entail a loss of a right of residence.
So just give me one moment, if you would.
Yes, of course.
Yes, I think both of you, or at least two of the three submissions, there was reference to Article 12 and 13 in the skeletons. Neither of you have taken us to them. They're not material, you don't.
They're not material to this case, no.
No, I understand they're not material to this case, but are they material to how all this is meant to work?
In so far as they show this, that where the EU legislator has wanted to carve out a specific provision for specific circumstances which would otherwise effectively involve somebody falling foul of the ordinary requirements.
Yes.
The legislator's done so.
Well, yes, that's fine. You made that submission in your skeleton argument, I remember. Yes. And if you were about to come back and make it later, I didn't mean to anticipate it, but just seeing the reference to it here reminded me we hadn't actually looked at it yet.
No, my Lord's absolutely right. It's in my notes to go to. I'd actually avoided it because of the time, but I will take the court to it just very briefly if I can. Before I do it, can I show you what conclusion the court reached about the nature of derivative rights? That then provides the overall framework. That's at page 359, paragraph 50. The court says, as regards the rights of residents in the host state, third country nationals who are family members, attention should be drawn as a preliminary point to the settled case law that states that the rights conferred on those individuals are not autonomous rights of those nationals, but rights derived from the exercise of freedom of movement by union citizens. The purpose and justification of those derived rights are based on the fact that a refusal to allow such rights would be liable to interfere with the union citizen's freedom of movement by discouraging him from exercising his rights of entry into and residence in the host member state. Now, on the facts, the individual applicants in Singh failed because they didn't fall within the strict criteria of Article 13, which is dealing with divorce, because the ex-spouse that became had left Ireland earlier than was required effectively for Article 13 to bite. So the key points that the court is making here is that derivative rights are always there to enable the proper enjoyment of the EU citizen's primary right of free movement. That's the whole purpose of the derivative rights regime. And that's why I started with that point in opening. My Lord asks me about those articles. Can I take the court back?
Yes, only if you want to now. I really didn't want to.
No, my Lord, it makes sense. I perhaps should have done it initially. That Article 12 is at page 28. And this is the retention of the right of residence in the event of death or departure. And you'll see in paragraph 1 how the legislators approach the issue. That prejudice to the second subparagraph. The union citizen's death or departure shall not affect the right of residence of his or her family members who are nationals of a member state. But that's on satisfaction of certain conditions. You'll see before he acquired the right of permanent residence, the person must meet the conditions laid down in Article 7.1 A, B, C, D. And then 2, without prejudice to the second subparagraph, union citizens death shall not entail the loss of the right of residence of family members who are not nationals of a member state and have been residing with family members for at least 1 year before the union's citizen's death. And there's further provision made in the second subparagraph.
So you say that the obvious implication, which totally fits with the structure of this, is that but for the special provision made, a derivative right will lapse with the enjoyment of EU rights by the sponsor.
Exactly.
Yeah.
Exactly. And that's why it's so important to always establish and maintain the connection with the sponsor. So in a situation like this, where on any analysis, whatever's said about earlier periods of work, the relationship has broken down, there is in essence nothing that the derivative right can protect.
And really, we needn't look at the details, but Article 13 is the same, but deals with divorce.
Exactly. Exactly.
Okay.
Exactly. And then in terms of the other relevant provisions of the directive, Article 14, as we're there, I do need to take you to, because this becomes very important in GV. So Article 14 is the retention of the right of residence. And Article 14.2, union citizens and their family members shall have the right of residence provided for in, for example, Article 7, as long as they meet the conditions set out therein. So in a sense, it's of a piece, but perhaps the other side of the coin, with the special provision in Articles 12 and 13. So it reiterates that you need to continue to meet the requirements for the rights of residence, including if you're a family member, for as long as, or you continue to enjoy the right of residence for as long as you meet the conditions set out in the right of residence. Fundamentally, it is not to slightly bend the phrase, one strike and you're in analysis. You have to satisfy the conditions at the outset, but you have to continue to meet them. Where the legislator accepts, for good reasons of public policy, death and divorce, but that's not the case, the legislator makes a special provision in Articles 12 and 13. Again, I don't go back to the detail. But structurally, and as a matter of principle, that's how that works.
Where does this ultimately lead to? You're urging us to adopt a strict construction of the relevant provisions because of this. In this case, the principal person's right of residence has persisted throughout and continues to persist. There's no doubt or dispute about that.
Correct.
You could have a situation whereby a child is estranged, then is reconciled, and is estranged and reconciled. Family life can be very complicated. How does it operate in those circumstances?
Well, no doubt much will depend on the facts, but in this situation, under the system of the Withdrawal Act, you have to be able to demonstrate that you satisfy the conditions as at the end of the transition period. So what you're looking at for the application that was made here was the position in law and on the facts at that point in time. So if she had perhaps the relationship had lapsed, but they had reconciled by the end, then it might be a different situation. But the point was, at the time that she made her application, the relationship had completely broken down. Indeed, it had been broken down for a period of some 3 or more years by that point, 3.5 years, I think, by that point. So whatever might be the situation on different facts, there can be no dispute that here it had broken down.
Gosh, it doesn't have to make the rules unpredictable. You may say that's just what it is.
My Lord, in my submission, not so. I mean, the EUSS makes that quite clear that that's what you have to do. And actually, it's not that it's unpredictable, it's that it's predictable, but facts change. Any system of facts may apply in different ways at different times in any legal framework. But there is a public policy that drives through, and always has driven through, every system of protection for family member derivative rights in EU law, both before and after the UK's departure. And it has always involved the derivative right being present and enforced in order to enable the enjoyment of the primary right. This court has often been concerned, for example, with Zambrano rights. In a sense, that's the very extreme, one of the most extreme points, perhaps the most extreme point in the derivative rights regime, because it's dealing with what is usually a purely internal situation. But again, the purpose, even there, is to enable primary enjoyment of an EU citizen's rights. And indeed, my lord, if that is the case, even if I'm wrong about that, and the system is unpredictable, that's not, we say, the fault of the EUSS. We say that is the proper interpretation of EU law. These submissions, of course, go to establishing what EU law requires, and if I'm right about that, then that's the nature of EU law. And perhaps we want to look at it in a slightly different way. There is always, in any immigration law system, including EU law immigration, and the Withdrawal Act system and the EUSS, there is a public policy decision to be made and a public balance to be made by the legislator. Now here, one can well understand in principle why the EU legislator would say, in order to give effect to the primary right of residence of an EU national, we have to give a derived right of residence to a family member who is a child under 21. Putting it very bluntly, what parent would leave their children behind if they wanted to move and take up a job somewhere else? It would be quite clearly destructive of the ability of EU citizens to move.
More accurately, they're dependent. One of the annoying things is the word child is completely ambiguous, but their child or their dependent, yes.
In the descending line.
Child over 21 who's dependent.
But one can understand why 21 is perhaps the age which is picked. Obviously, up to 18, a child is in.
Includes education, but it doesn't really matter. It is the basic thinking behind it is that up to 21, you can be expected to be dependent.
Exactly.
After 21, you've got to show that you are dependent.
And doubtless many 18 and 19 and 20-year-olds are not dependent, but they have the benefit of this drawing of the line by the EU legislature. The EU legislature could have said, no, it's 18 or bust.
Yeah.
And after that, you go out into the big wide world, and what happens is what happens. And parents who are moving have to deal with that. They didn't. They gave an extra degree of protection for understandable reasons. Beyond 21, the impacts of giving an unrestricted right to the labour market are potentially very significant. So one can understand why, first of all, you have dependency as a criterion. The legislator could have said, well, you can have any children. If you've got a descending relative, forget about parents for the moment, but you've got a descending relative, descending line, doesn't matter what their age is, I want to treat you equally with nationals, because the debate today has moved a long way beyond the way it was framed in the skeleton argument, and there's been a very significant argument, equal treatment, on Article 24. Now, I've got something to say about that in a moment, but the reality is there is an element of discrimination and unequal treatment hard-baked into the directive from the outset, because a national of a member state can have their child living with them and have their child access to the labour market if they're a citizen of that member state. But the legislator has drawn a distinction and said, well, actually, it's not all children that are going to get some kind of access to the labour market. It's only those who are either under 21 and query what employment is likely to mean. It may well be quite a minimal impact on the labour market then, with all that entails, given that it may be a small number of children and that those working full-time may be a limited cohort of that. But either way, once you get beyond the age of 21, obviously you're looking at the ordinary situation where somebody would be seeking to work.
Yes.
So the public policy imperative to draw the line there is strong.
Well, speaking for myself, and possibly only for myself, I do see a lot of force in those points, but something you're obviously going to come to at a later stage in your submissions, not now. That's not how the European Court appears to have struck the balance, or to have, that's not the right word. That's not how they have analysed it.
Yes.
But you can go a long way to persuading us that dependent ought to mean dependent, and if you lose your right to dependency because of working, that's not contrary to the spirit of anything. It's inherent in the concept of a derivative right.
Yes.
And the thinking behind allowing you to bring your dependent but not your independent children with you. All that is fine, but that's not the way the European Court has decided it.
Well, it's not quite what Article 23 says, is it?
Well, my Lord, I was coming to Article 23. Perhaps now's the moment to do it.
Well,
my Lord's
maybe it is, maybe it isn't. I'm sorry, this always happens, and we get taken away with points that interest us. I was really just flagging up that at some point you'll want to make your points, and please do, but at some point you've got to face up to the fact, as I see it, that the CJEU hasn't bought this analysis.
Well, can I at least just I'm going to come to Reyes and GV if I can at the end of my submission.
Of course, no, that makes sense.
But can I headline this submission? With respect, we don't accept that's the right analysis of those decisions. And there is in our submission a very significant difference between what the court has said about first of all, the right to take up work, and the wording is important, in Reyes, which was a case looking and establishing that you look to the past and not hypothetically to the future. And then GV, harking back to Le Bon, which deals with social and tax advantages under a specific...
Well, I knew you'd say that because you already said it in your sentence. So that's fair enough. I'm apologising for taking you away from your course, which seemed a sensible one. You were taking us through the legislative provisions, making the points you wanted to make about them.
Well, Lord, I'm grateful. I just wanted to headline that so you had at least where I was going direction of travel, as it were. The next, I think, I've taken you to Article 14. You've seen what I say about that, and I'll come back to how that's relevant when I come to GV, because that's when it next features heavily in the analysis. The next relevant provision, I think, really is Article 23, and the terminology is important. So I'm just looking over my notes to see that I've gone through the rest of the material. Yeah, so Article 23 at page 39, my lords. Importantly, given the way this has now been argued today, it's headed related rights. And the right is this: irrespective of nationality, family members of a union citizen who have the right of residence. So first point, they have to have the right of residence to begin with, or the right of permanent residence in a member state, shall be entitled to take up employment or self-employment there. We say the language of the provision is significant. First of all, it only applies if you have a right of residence already. You cannot use it to establish a right of residence. I'll come in a moment to some of the case law, which is also relevant to the context of equal treatment in that respect. Secondly, what it is effectively a right of access to employment. The wording is, shall be entitled to take up employment or self-employment there. So it's a provision which tells you you can't be locked out entirely from the labour market. You're entitled to work. That's the first question. That's always the first question. Can you work at all? Yes. But thirdly, the provision says nothing about the extent of employment that is permitted. Building on that, fourthly, it is described as a related right. So related right to the right of residence. It is not described and is not a right of equal treatment. Rights of equal treatment are different as set out in other places, and I'll come to that in a moment. And indeed, next on that, for the right of equal treatment...
Just before you leave the text of Article 23, I, for my part, accept your submission that this is nothing to do with equal treatment. Equal treatment, if it comes in at all, comes in later. But Mr. Butler says, I don't need equal treatment. I can win just on Article 23 because clearly the legislature intended this to have some practical effect.
Yes.
And he says that there is a logical contradiction in Mr. Justice Lane's interpretation of this provision, because the very act which allows a family member to exercise this right, which is to take up employment, will then be self-defeating, because by taking up employment, they will render themselves not being a family member.
So my answer to that is no, that's the wrong analysis. So with respect, the reason why my learned friend has sought to rely so heavily today on equal treatment is precisely because this is not an equal treatment provision.
All right, but what is your actual answer?
So the answer to that is two parts. First of all, it is a broad right to access the labour market. So you can work, and you may well be able to work up to a point on the facts, which does not create any difficulty with dependency. So to take one example, given this is applying potentially to people who are still in tertiary education, the age of 21 and over, perhaps somebody doing a master's, whatever it happens to be, somebody could work perhaps in their holidays but still be living at home with their parents, receiving material support. The holiday work is highly unlikely, depending on the facts of course, but highly unlikely to make them financially independent, particularly not if they're pursuing courses of studies. So it's entirely possible and entirely predictable, we say, that access to work is effective, is a real right. In other words, you give the family member a right to do something which has a real benefit to them. They get work experience, they earn some money, but they're not financially dependent, without it affecting the question of dependency.
That's reading a lot into those words, isn't it?
But my lord, that's because they are broad words. They're capable of bearing that meaning. And of course also...
Why didn't the legislator simply say that you have a right to work, but not in a way which would prejudice dependency?
Because you don't need to, my lord, because you have the requirement for dependency in Article 22C Lim 2, plus the Article 14.2 requirement to continue satisfying the conditions in order to benefit. And that, of course, we say is the first finding and the really crucial one in GV.
Can I ask about almost the broader policy, the ex-ante incentive on the Union citizen to move from Italy to the United Kingdom, bringing his or her family with them, upon the basis that their children will have no right to work insofar as it will diminish their dependence upon the parents. What does that say to a 16-year-old going into an apprenticeship or...
Well, it had to be a 21-year-old.
21-year-old. Well, why would you go? Why would you take the children with you?
Well, what that says is the EU legislator has drawn a line, and the EU legislator has decided that not all children will be able to benefit from a derived right of residence once they hit the age of 21. Well, the age of 21, yes, so the apprenticeship age 16, may well be able to do. And of course, if they achieve 5 years here in their own right, then they may not need any further assistance from the parents' status, as it were. But that was my point when I made the sort of high-level submission a moment ago about the purpose behind where the legislator draws the line. It's entirely, in my submission, understandable that the legislator has said, well, hang on, this is the effect of the provisions. I'm not going to allow every child of every EU citizen, irrespective of nationality, to come here and have a full right to work, an equal right to work with other nationals of this state. I'll allow them to have a right to work, so they can come and they're age 21, finishing university perhaps, finishing a college course, they can get some work experience. They can supplement their income.
You have an apprenticeship and you're paid not a subsistence level, so you live with your parents and you're dependent upon them. At the end of the apprenticeship, you're offered a job, at which point you have to leave the country.
Well, that may be the case. There will be hard cases, but there is a line...
What's the logic behind that in the context of free movement of rights of the Union citizen?
The logic is that this is a provision which is not just protecting the right to work of an over 21-year-old child who is able to access the labour market in full, but also the right to work, for example, of spouses, the right to work of children under 16.
Was this your second point?
This is the second point.
Yes.
Exactly.
This isn't really particularly directed at children.
Exactly. And indeed, in my respectful submission, it would be reading far too much in to this provision to let the tail of Mr. Butler's argument wag the dog of what the legislator's done.
Let's just hit it. The family members who do not have to show dependency, and who therefore this wouldn't be a problem for, are most obviously spouses.
Correct.
Children in the ordinary sense, let's say up to 21, but who might nevertheless want to work. And that's really it. I think everyone apart from spouses and children have to show dependency. So if it's grandparents, if it's parents or siblings, maybe the siblings aren't in at all, I can't remember, but they've all got to show dependency.
Yes.
So you're really saying that this provision as a whole would not be rendered self-defeating. It wouldn't be self-defeating at all for spouses or children under 21. But it would be rendered self-defeating for some of the people who might fall within its literal words.
But not even the entirety of the cohort of those who are dependent over the age of 21. And that's important. This is only because of your holiday pay point, your holiday work point. Yes, but
all right, I'm not dissing it, but I don't regard that as the... that doesn't strike me as likely to be the heart of the argument.
Well, perhaps
right, no, you
not, but it's an important limb of it. And actually, given that the EU free movement suite of rights includes, of course, educational rights, Gent, Texera, all that line of cases, Ibrahim, the rights that are set out in the subparagraphs of Article 7.1, actually, the ability to have access to a labour market if you are pursuing, for example, college studies, may be very significant. It may mean that you actually make your ability to access an educational course really significant because you are able to get real work experience. It may mean that you're able to at least supplement your position in the way that many students do and many people in the early years of work do, by being able to work in that sort of way. So in my submission, with respect, it's not, I accept it's not the core point, but the point is, if you come back to the wording of Article 23, A, it's not an equal treatment provision, and B, if it's not an equal treatment provision, well, what is it? It's a right of access. The position otherwise would be open to a member state to say, well, I'm sorry, but you, the dependent relative, have no right to work here at all. You can't even begin to consider working because that's always going to have some sort of impact on dependency. Whereas what the legislator's saying is, well, if you have family members, generally they can work. That will also benefit some who are dependent. But they may not be able to work full-time and earn a full salary, otherwise that will destroy the dependency. But that's understandable for the public policy reasons I've already indicated.
Yes, you're saying the EU, not just EU people into Britain, it's all over this. All member states will have their feeling that,
yes,
that you can't, by allowing adults to come and work here, give their children in the broad, their descendants in the, whatever it is, direct line descendants, what, 40, 50-year-olds?
yes.
Can they come here?
Exactly.
I've been trying to see how this works in the real world by reference to what might be called a commonplace scenario. I noticed that the legislature uses the word accompanying.
Yes.
So if you say, I don't know if it's helpful, but I hope it is, if you have, let's say, a university academic in Germany, who's a German national and has a child aged 25, and they're offered a chair at a British university. And so, I'm speaking for myself, I can readily understand that if they've got children under 21, they might well think twice about taking up a chair in Britain.
Right.
And so I think what you're saying is the policy underlying the balance the legislature struck was, well, with those people, you don't have to worry. Basically, just as they can be with you in Germany, so they can be with you in the UK. So
yes.
fine for those up to 21. But the 25-year-old may already be working in Heidelberg.
Exactly.
It is. So there, I think what you're saying is that the policy choice which the legislature has made is, well, okay, if that person is dependent on you at that time, then they can come with you, they can accompany you.
Exactly.
Is that the point?
That's the point.
But then after that, well, there's no, as it were, freestanding right for them to enjoy access to the UK labour market. It may be that if they're unemployed or something like that, age 25, well, they'll have to go back to Germany and work there.
Yeah.
Is that the point?
Essentially, Model, that's right. And one can see why, it comes back to one of my earlier points in argument, a parent moving with a child aged under 21, the assumption at least, and it is assumption, in the De Pesmo case, it's described as a presumed situation of dependency. No need to turn it up, but that's uncontroversial. There's an assumption made, no doubt for the sake of ease of operation of the system, that there is dependency there. Once you get to the age of 21, it's not an unreasonable assumption to make that most 21-year-olds and above are going to be independent. But there will be some who are not. And there'll be a whole host of reasons why they are materially dependent on the parents in a way that means the parents would not move if they were not able to bring the child with them. It may be for health reasons.
Yeah.
There may be all
may
kinds
just be doing a long academic degree. Or
maybe doing long academic. Yes, exactly.
Can I ask you this? The difficulty I have with the argument is that you've described coherent policy, but you're writing into Article 23 a whole series of rights and limitations and curtailments and caveats. And one would have expected that if if that was the case, you'd have seen them spelled out, because it's really quite a complex and subtle regime you're describing, and it's not there in the language unless you read an enormous amount into it. It's almost a drafting issue. It's not what one would generally see. If it existed, you'd expect to see it in recitals, in subsequent legislation. It's been around for a long time.
Yes.
But there's an enormous amount you're injecting into Article 23 to get your policy.
Well, I think what you say, Mr. Blundell, is that it's all within the definition of family member.
Yes.
And the requirement to continue to qualify.
Exactly. So you have the primary definition of family member. You then have Article 23, and I entirely understand my Lord Justice Green's point, but the answer is that has to be a broad-based form of wording which is capable of covering a multitude of situations precisely because it's dealing with the full panoply of family members. So the family members who are not dependent are very easy to, if you like, slot into that analysis. The ones who are dependent, one perhaps has to think a little bit more about why that is. But in my submission, it's not my, but rather the Secretary of State's analysis that reads too much into the words of the Article 23 right. It's actually my learned friend. Because in truth, what he's trying to do, before he gets to Article 24, is derive a true equal treatment provision from it, which it is not.
Well, we'll come to that in a minute. I'm just looking at what it means in itself. Yeah. Well, I think we've done that to death. I mean, it's well, you may be more points you want to make about it.
No, my Lord.
But that is the argument about Article 23.
I haven't killed the court.
And I've probably already hinted that I find it quite attractive, but I'm not sure the Court of Justice has.
Well, I better get to raise the GP.
But we'll get that. But anyway, yeah.
Who I say so, I think that the high point, certainly as I see it, for Mr. Butler, is paragraph 32 of Rays.
Right. I'm forewarned, not forearmed. I need to go there. I'll go there.
Well, you've got plenty of time.
Yeah.
Fair amount of time. So don't rush over the intermediate steps, and it may well be that.
No, it's extremely helpful to have
my Lord and I have given you about our view may not be shared by my Lord. So if you want to go on trying to persuade him, please.
No. I think I've made the submission I wanted to make about the breadth of the right in Article 23 vis-a-vis the requirements on dependency in Article 22C. I've made that point, so I'm not going to make that again. I don't think it will get better by repetition. Can I deal, because it's been raised, and I'll try and do this as quickly as I can, with Article 24. I am, famous last words, I'm not taking a pleading point, but we are concerned with the emphasis that's been placed on Article 24 today, given that it doesn't feature at all in the learned friend's skeleton argument. I entirely understand the point that one has to read and understand and interpret the full suite of the legislation and the legislative provisions, not taking bits and pieces out of context and reading them without their proper contextual background. However, it is a very broad and expansive equal treatment argument that's been advanced. I invite you to reject that argument in its entirety. Can I make 5 short points?
Yes, sorry, I've just lost my pen. Okay, 1 second. I found the pen, but I've lost the ink, I could say more precisely, but I have a spare. Yeah.
By way of introduction, we say you should be
We say not featured in the skeleton, and just to make that complete, or argued below.
And not argued below.
Yeah.
So there was a discrimination argument below, but it was, if I recall correctly, it was a common law discrimination argument based on Mattadine and Pointed. Oh, yeah. Lord Hoffman's famous statement. Yes, about rational treatment and equal treatment. Effectively, yes, equal treatment being the hallmark of rationality. We say you should be very cautious about accepting any of the detailed arguments that are being made today in circumstances where this is the first time that it's been raised. First of all, as I say, not been raised before. Secondly...
So that was your first point.
That was my first point.
Yep.
Secondly, the EU equal treatment principle is expressed and treated in different ways in different instruments. So, for example, Article 18, TFEU, Article 7.2 of the regulation, you've seen reference to that in GV, I'll come to that shortly, and then Article 24 here. You can't simply mix and match them or try and construe one through the prism of another. So in other words, Article 24 through the prism of Article 72 of the regulation and apply it to situation for work. They are dealing with and protecting very particular things for particular purposes. Again, I'll come to that with GV. Third point, Article 24, if you actually look at the words, somebody only benefits from Article 24 if they have a right of residence. You can't establish a right of residence on the basis of Article 24. So if you just look at the wording on page 40, they're subject to such specific provisions as are expressly provided for in the treaty and secondary law. Well, we'd say that effectively would be a carve-out for the dependency requirements anyway, and indeed for the work provision anyway. There is specific treatment for work given in Article 23, so you don't look at Article 24. All union citizens, etc., shall enjoy equal treatment with nationals of the member state within the scope of the treaty. Benefit of the right should be extended to family members who are not nationals of the member state and who have the right of residence or permanent residence. So you have to establish the right of residence before you get to rely on the right to equal treatment. It's an ancillary provision. You don't establish the right of residence through recourse to equal treatment. It's the wrong way around.
Bootstraps.
Bootstraps.
Didn't the appellant have the right of residence, even if not the right of permanent residence?
No, because the appellant here was applying for pre-settled status. So if they were dependent, they wouldn't have any right of residence. Sorry, if they didn't satisfy the dependency conditions, then they wouldn't have the right to reside.
So does that actually mean that at the moment, at the date of her application, the date of application, she was not here unlawfully, but only because of the pragmatic consideration that she was given 5 years residence card?
Well, that's only that's declaratory, not constitutive of a right to reside.
It's all right.
So
All right, okay, but
yeah.
so far the withdrawal agreement did not give her a right as a child.
No.
Who was, well, at the time she applied for it, she was a child and, let us assume, was dependent.
My lord means in 2014 when she came in.
Well, she got the residence card, I think, very shortly afterwards, 2015.
Yes, that's right. That's right. And
that was, you said, was for 5 years.
Correct.
So I take the point about declaratory, not constitutive, but the fact is she was here lawfully, what, dependent or not.
Not once she reached her
I
majority.
see. So the Secretary of State probably would never have done this, but the Secretary of State would have been within his or her rights to say, I know you've given you a residence card for 5 years, but I notice that actually you're over 21 now and you're not living at home and let's get away from this, you've won the lottery.
Yes.
And I'm afraid you better go back and spend it in wherever you came from.
In practice, that doesn't happen because there aren't consistent checks.
No, I understand that, but I just want to say conceptually.
Conceptually, that's right.
So it is entirely consistent with your position that although it would never have happened, because she held a residence card and nobody ever questions it during its currency, she could have been expelled before she made the application.
Correct.
Well, there might have been domestic law.
Correct.
Or EC
Or accolades, yes.
Absolutely.
But the point is, nothing derived from EU law
Yes.
would have stopped that happening.
And no argument has ever been made that would be the case.
Yes, I just wanted to get that clear. That seemed to me that must be your position.
Yeah. Well, that's right. That's absolutely
I mean, as my lord said, there are all sorts of reasons why, administrative and perhaps legal reasons why it couldn't happen, but not under the agreement.
No, my lord, that's exactly right. My lord, can I just go to make good? I may not need to.
And to be clear, sorry, it's not under the agreement, and nor under the 2016 regs. Because those were, during most of the time we're considering, those would have been the
yeah, and sorry, yes, and I'm being rightly reminded, of course, at the relevant time it would have been under the directive and the regs rather than the withdrawal agreement.
Sorry?
It would have been under the directive and the regs.
Yes, well, that's really the point I was just
Yes.
making. But it's same difference for these purposes.
Same difference, exactly. Well, the point I've made, one gets, we say from a clear reading of Article 24, that you need the right to reside. It is also the finding of the European Court as well, in a case called CG. That's the case which should be on the bench in front of you.
Yeah, it is.
So CG, the facts are set out in the head note. CG was somebody who was effectively in the broader cohort of EU nationals who were present in the UK, but not exercising treaty rights, to use the old-fashioned term.
Sorry, just so I don't lose my structure, because you were 5 points. Is this the third one?
It is.
This is all part of that still after?
The third one is slightly longer than the other.
No, that's fine. I just want to know how it fits in. Okay.
Yes. Yeah. Sorry, I should have given a health warning, I think, for that one. The applicant was, as you'll see, dual Croatian and Dutch, moved to Northern Ireland, was granted pre-settled status, giving her 5 years limited leave to remain. But she was granted pre-settled status without actually being economically active in any way. So she was the broader cohort of people protected under the EUSS. The course, I think, is aware that the approach of the Secretary of State was a generous one, in that when it came to implementing the Withdrawal Agreement, he didn't just, through the EUSS, protect people who were exercising a treaty right at the time, but they were present here. So she was in that broader cohort. Yeah. And the question then came as to her entitlement to universal credit. She was not allowed to get universal credit. That gave rise to the proceedings, which ended up before the European Court. The relevant passage begins at paragraph 74. To save tiring the court with my voice, can I just ask the court to read from 74 onwards? It's at page 5961 of the law report through to paragraph 80.
Yeah.
I'm grateful. My Lords will have seen perhaps the main, well, I made the court to bear with me and read quite a long passage. The key really is in 75. The court's held that as far as concerns access to social assistance, union system can claim equal treatment only if his or her residence in the territory complies with the conditions of the directive. That was established in the earlier Dano litigation, which is very important in this field.
So I remember the case well as your. We had a lot of this in AT.
Yes.
I could almost cite it verbatim with my eyes closed. I don't want to, it's a nightmare. But those paragraphs then led to the court, and I'm just remembering now.
Yes.
They say, even though the principle of non-discrimination rises, nonetheless, because she was exercising a broader right of free movement, other rights were then triggered. So what did you deduce from this? Where does this...
So what I take from this is...
I know Miss Smythe was in this, in fact she's been in all the cases.
Well, we were both...
Tell you what the relevance is if you're not...
I deduce that I always take my answers from Miss Smythe. I think that's the correct approach for me. We were both in CG, but Miss Smythe was in AT, of course.
Yeah.
On this, what I take from it is really the principle of paragraph 75. So I've contextualised it a bit by asking you to read the longer passage. Yeah. I think the point that my Lord has in mind is, of course, the treatment of the Charter via Article 21.
Which is not coming in this case.
Not coming in this case.
So you rely on the word only, do you, in the line 3 of 75, is that?
Oh, exactly. Only if his or her residence in the territory complies with the conditions of the directive.
Yeah.
Yes. And Ms. Smythe reminds me rightly that what follows in terms of the analysis hinges on the grant of pre-settled status. So CG did have pre-settled status.
She did.
Of course, this appellant does not. The whole point is she was applying for pre-settled status and didn't have it. So you can't use, I've used this already, but you can't use different ones. Reverse engineer rather than let the tail wag the dog. And my Lord, just for my Lord's note, I don't seek to go to it, but there's a similar analysis, in fact, in Le Bon at paragraphs 12 and 13. I don't seek to turn it up, given the time. You'll see what that says. My Lord, that was my lengthy third point. Fourth point, Article 7.2, and here I'm really preempting something I'm going to say in relation to GV, is a bespoke
Article 7.2 of the regs.
Of the regs, sorry, of the regulation, yes. And my lord, I'm not sure you've actually seen it. Can I just show it to you?
We have seen it.
You have? I'm sorry.
But, or rather in passing, we have seen it.
Yes.
Show it again if you want.
So notice it's at page 52, which is tab 3. And it's very short. He, that's the worker, shall enjoy the same social
Well, out of curiosity, though, this reg is... What's it? We've just been given one article out of it. What's it for? We've got the Citizens' Right Directive already.
So it makes further provision for the position of migrant workers. It's the successor regulation to Regulation 1612/68, which regulated the position of migrant workers across the EU. EC, I think it may have been. Yes, EC it would have been at the time.
Yes, I see. Thank you.
Yes. And some of the matters in Regulation 1612/68 were incorporated in the Citizens' Directive when that was introduced. So this, in a sense, flows from that consolidation of the EU legislative piece. But Article 7.2, as I say, is a bespoke regime for workers who pay tax. The reason I stress that is because that's...
Sorry, hang on 1 second. It's a bespoke regime for workers who pay tax.
And I get that from GV. There's a passage in GV right at the end which provides the rationale for the protection.
You mean which is GB? I've got confused.
So
GV.
GV.
Oh, sorry. Yes,
I'm sorry. GV. There is no case law that you've been referred to. As far as we're aware, there is no case law, full stop, that treats an entitlement to take up work as a social or tax advantage, either directly or indirectly, under Article 7.2 of the regulation. That's because it's not. No matter how broad, and it is a broad category, social and tax advantages, it's not capable of encompassing work which is subject to different provisions and different issues.
Are you saying that it doesn't apply to assist workers who, for example, may fall below the threshold for paying tax, even though they are, in every other respect, a worker?
No, my lord, all I'm saying is that work in principle is not itself a social tax advantage. So as I understood my learned friend's, one of my learned friend's submissions as well, I may have got it wrong, but as I understood what he was saying at one stage was, there's no reason why you can't understand work itself as a social tax advantage, or rather the right to work.
Yeah, so speaking for myself, I see the force of your submission. We'll have to consider whether the authorities support it. But I understand it conceptually. But what I have in mind by way of social advantages is a much broader concept. It is the idea that, for example, you'd like to live in the same country as your children, because it's just easier. You know, when they want to come for Christmas, birthdays, and so on, it's all much easier. So I take my Heidelberg example again.
Yes.
You've got 25-year-old adult children. They're working in Heidelberg. In principle, I can understand the argument that it's a social advantage if they can be in the UK, where you're spending most of your year. I can see that point. Where it gets anyone, I'm not sure.
Yes, but it's certainly not.
Sorry, no, let you answer my lord first.
No, all I was going to say then, to pick up that, on one level, that's right. But if that were then capable of falling within the scope of social tax advantage as understood in the prism of Article 7.2, that would include almost everything. I mean, that would mean that the hard-baked-in discrimination that I talked about at the outset is totally meaningless.
Well, that's what I was about to put to you. This is the first time I've come across this phrase. In the first place, I'm surprised there isn't any case law about what social means. But I would construe social eius generis with tax. I agree it doesn't say social security, but I suspect...
I think it's been interpreted much more broadly than that.
Well, if there's case law...
I'm not sure what matters in this case.
No, all right.
No. But it's a red herring. But I don't want to say something in our judgments which is wrong about social advantages when it's got nothing to do with the present case.
What I can certainly say is it has been interpreted quite broadly to cover a range of social security in the broad and English sense. benefits, social welfare, social assistance benefits.
I think it's gone much further than that.
But it hasn't gone as far as to include either.
That I can understand. That I certainly understand.
Or to pick up my
It may be the right way to do, as I'm got my eye on the clock, is just in case we go wrong on this and go wrong on we say something inappropriate, I think it would be useful just to have ideally a joint note, but if not separate notes, just drawing us preferably to one case or two or three key cases that say what the case law is and what a social advantage is.
Yes.
And that will just make sure that if we have to allude to it, even though it's not going to be the centre of our case, we get our definitions right.
Of course, entirely understood. We'll do that. Can I just make this final point in relation to my Lord Justice Singh? In terms of the Heidelberg example, the other way of responding to that is that in terms of one looking at, it might be nice if you were able to have your children of any age living with, and no doubt it is. Of course, the directive is the lex specialis on residence rights. So that's why it's a red herring.
Sorry, the regulation.
The directive, so the citizens' directive sets out a specific law on residence rights.
I see, yes.
So that's why, no matter how broad 7.2 is, it can't go that broadly.
No, I see the force of that point, if I say so.
I'm grateful, man. That was my fourth point. My Lords would be grateful to hear that my fifth point was really to draw that together and say that the non-discrimination argument in my submission does not assist my learned friend and is one that needs to be approached, as I say, with real caution. To make a related point, if we knew we were meeting an argument, for example, about indirect discrimination, and that the purpose of imposing a dependency requirement were at issue, we might have wanted to file evidence, policy evidence, as to why it's important to have that there, and that might well reflect, for example, evidence about impact on labour markets and so on and so forth. The court will be aware that sort of evidence is filed occasionally in these sorts of cases. But that's one of the reasons to be cautious about this argument.
Well, that's what happened in the Equal Opportunities Commission case and the Seymour Smith case, I think, later on.
Absolutely. That's right. And often one will refer to, I think there is a Social Security Special Committee that examines some of this sorts of legislation. Often you get their reports in these cases.
There's a dispute about that. Now, so those are your points helpfully on Article 24.
Yes.
Are we now able to go to the case law or not quite?
Yes, absolutely. And I don't need to go to anything in the withdrawal agreement itself, save for just giving you the reference to the judge's treatment of Article 17.2. I don't need to go to it because it's no longer relied on by my learned friend.
Right.
But it still contextualises some of what we say in terms of his
But it is relied on by you as saying
Right.
it wouldn't be necessary
Exactly.
if the broad case were right.
Exactly. Because you would be able to simply rely on your one-off, effectively presumed dependency. You wouldn't need to carry anything over. Can I just give you the reference, given the time, to where that's dealt with, we say comprehensively, and without challenge now, in the judge's decision? It's in full at paragraphs 80 to 96, at pages 81 to 83 of the core bundle. And see especially paragraphs 94 and 95. Well, can I then go to my submissions on the cases?
Yes.
Reyes, first of all, your reference tab 14, page 318. Don't need to go through the facts in any detail at all. My learned friend's very fairly done that. First point we say, though, to note, really from the fact that as a matter of principle by way of context, is that this is a case about a first application for a right of residence. The significance of that becomes clear and accepted in the second case, GV, that I'm going to take you to. But that's relevant then. To the extent that the court considered the impact of the prospect of work in the future, it was looking at the impact in the future on an application in the present, but where the relationship with the sponsor, uncontroversially, continued and was undoubtedly in existence. So there was no question but that dependency existed. The issue was a hypothetical one. can this person be refused a right of residence because they might actually engage in remunerative work when they get here? And in relation to then the second part of the analysis, they might be very well suited to doing that. They might be very well qualified. So we say this is determinedly not examining the situation where there is no present dependence, and still less where the existence of the relationship with the sponsor is no longer in existence. It's about acquisition, not retention. That, too, is an explanation for why Article 14 is not considered in REA. So Article 14.2, the requirement to continue satisfying the conditions, it simply wasn't an issue there. It's entirely hypothetical. And you see that, we say, in the actual questions that are referred, you'll see those. My Lords, at paragraph 18, you've seen them already. Don't need to go through them in any detail again. But they are dealing with the position where a member state seeks to impose additional requirements beyond the existence of the question of dependency. And the second question in particular is looking at a hypothetical situation depending on the characteristics of the individual concerned. Well, to save time, can I give you my submissions on the first question and how that is treated, rather than going through the text of the judgment again, given you've seen that already in detail today? Got 9 very short points, bullets really.
Going to the first question, you mean?
So the answer to the first question, which begins...
The first question referred by the Swedish court?
Exactly. So it begins at paragraph 19, and that runs through to paragraph 28, rather than going through in detail the text.
You can, of course, though, as it turns out, I don't think that's really relevant to the case against you seems to be based entirely on the answer to the second question.
Well, my Lord, in that case, let me go
through if I've got that wrong...
No, but no, my Lord, and indeed, Lord Justice Singh earlier on indicated that, as he put it, the high point of the case is really paragraph 32. So on that then, can I go to that next? I'll leave these submissions on the earlier part. That is, indeed, that's uncontroversial, that's uncontroversial. We say the following 3 points are clear from the analysis of the second question, paragraphs 29 to 32. First of all, the situation of dependency must exist in the state of origin at the time of the application. Secondly...
Hang on, sorry.
Sorry.
Yes.
Secondly, the prospect of getting work is not to be taken into account at that stage. That's the hypothesis. You look at the facts as at the date of application, not the hypothetical future.
Yeah.
And then thirdly, and this is really the answer to paragraph 32, that's because such an approach would in principle prohibit the applicant from looking for work and would infringe Article 23.
Hang on. Yes.
So the conclusion, to deal with paragraph 32, the conclusion that's drawn there, that if you look at the possibility, if you take into account the possibility of obtaining employment and the well-suitedness of the individual applicant for doing so, then that's a hypothesis which is going to exclude potentially all possibility of engaging in work. Now, that's relevant in 2 ways. First of all, it's a hypothecated analysis. And that's what you must...
Hypothetical.
Sorry, hypothetical, not hypothecated. Definitely not that.
Yeah.
I apologise. Hypothetical analysis. But secondly, that sort of hypothetical analysis, because it excludes the possibility of all work, that will infringe Article 23, because Article 23 enables you to take up work. But as I've already indicated, what it doesn't give you is a right of equal treatment and equal access in the labour market. It simply tells you can do it. If it's a later stage, you do in fact work and engage in the labour market, then there will be a question as to whether that has now rendered you no longer dependent. But that's no longer the Reyes situation, which is offensive in paragraph 32, because it's not done on the basis of a hypothesis. It will be a fact-sensitive, fact-specific analysis.
And of what has happened, rather than looking to the future.
Exactly. So it complies with the first of the points of my three, that you look at the situation in existence at the time of the application. In Reyes, it happened to be when you're out of country, but you might not be. And again, the language is significant. So they accept the European Commission's submission. As it points out, the opposite solution would, in practice, well, I have to add the in practice because, of course, there's no practical facts to consider. The only way the hypothesis could operate would be to say, well, this person has got lots of very good educational qualifications, they've got some work experience, they will therefore be able to gain access to the labour market.
Was the argument being run by the Swedish government that although this person is, as of now, in fact dependent on their parents?
Yes.
Because they might not be in the future, we're entitled to treat them now as not being dependent.
Exactly. That's essentially right. If you look at the facts...
That's the argument addressed in paragraphs 30 and 31.
That's right.
And Mr. Butler has made it clear he's not anymore seeking to draw anything from those, because I think he, whether he does or not, I can see the strength of the point that you made. That's not this situation. But the problem is the reasoning in 32 is not specific to that situation. It would be equally applicable to a situation of the present kind, wouldn't it?
Well, my lord, no, because that simply wasn't a scenario before the court. The only scenario before the court had to consider in Reyes, and this is, of course, the interpretation of Reyes taken in GV, I'll come to the relevant passage in a moment, is that Reyes was looking at the acquisition of the right, not its retention.
Of course it was, and this is obviously a problem you have also with domestic authorities, that a principle is stated in general terms, and we quite often say, yes, but that wasn't the factual situation that they were concerned with. And sometimes that's a good answer, and sometimes it isn't, because it's quite clear it's a general principle, and will apply in situation B as well as in situation A. And isn't that your problem here, that the reasoning in paragraph 32, though you rightly say these are not the facts of the case, would apply equally to a case of the kind we have here? Sorry, I'm repeating myself.
I think you're placing emphasis, I think, on the word would.
Exactly.
Would in line 2 and would accordingly infringe Article 23.
Exactly.
In other words, if certain scenario arises in the future, it would infringe Article 23.
And the reason why, that's with respect to exactly right, my lord, and the reason why would is so important and why that conditional language is used is if you look back at the question that's being answered, it's question 2 in paragraph 18, in interpreting the term dependent, does any significance attach to the fact that the family member, due to those personal circumstances, is deemed to be well placed. It's a deeming analysis.
Well, that's why I asked the question. The Swedish government was making the argument that because this person intends to start work in the future, we can deem them now not to be a dependent.
It was absolutely considering the hypothesis that they were well placed to get work when they got there.
But you're saying that this doesn't preclude the answer where those facts do arise at some point in the future. You still have to ask the question, is this person now still a dependent?
And in fact, that's the only way coherently and consistently to reconcile the 3 points in paragraphs 30, 31 and 32. Because you start by saying, well, when do you... That's why they start with that first point. When do you assess the situation of dependency and work? State of origin at the time of application. Question 1, answer 1. 2, can you take into account the prospect of work? No. 3, reason, because it would have that impact. It's all dealing with the hypothesis. Whereas when you're dealing with real facts...
It's dealing with a hypothesis. On the reasoning is, if that hypothesis happens, you will have an inconsistent situation with Article 23. And that's your problem, isn't Because why will there be an inconsistent situation with Article 23?
No.
Answer, because Article 23 gives you the right to work once you have the right of residence.
My Lord, with respect, no. It's not the eventuation of the hypothesis that creates the conflict with Article 23. It's the hypothesis now. So it's relying on the hypothesis at the date of the application that creates a conflict with Article 23.
It's
Why
denying,
is that?
It's denying present reality
Exactly.
by reference to future hypothetical facts.
They can't rule out what will happen in the future, but what they can say is you can't assume.
Yeah.
Because it would, conditional, in practice, what would happen as a result of that, prohibit from looking for employment.
And is that equally consistent with their reference to the submissions of the Commission, which we have?
In my submission, yes, and indeed, I understand why my learned friend's taking you to the submissions of the Commission. However, ultimately, they have adopted the submissions of the Commission in the way they've done here. There's nothing inconsistent with that at all in paragraph 21 that he took you to. But it's paragraph 32 that is the establishment of principle for very good reasons of transparency, if nothing else. You can't get anything more out of going back to a translation which his solicitors very assiduously, I think, have arranged.
It's not about translation.
Because they were in French. You haven't got them. You're not looking at the original language of the observation.
We got the French on the
French
facing
page.
page, as it happens. But the fact, this is a pretty explicit acceptance of the submissions in this paragraph.
Yeah, but I have no difficulty with that. But it's because the danger that's being guarded against is precisely the danger created by the hypothesis.
Okay, well, all right, but you're not taking the point about the translation because...
No, I don't do it for that reason at all. I simply say, I understand why he relies on that, but you have to look at what the court has actually done.
Yes, of course.
But I come back to it. It is framed...
Can I just take that point? I mean, we've all read many European Court judgments. Sometimes in the same way that they refer to the Advocate General, it's a sort of shortcut. We accept the Advocate General. You can go back and see greater length what the AG has said. They don't always say that they accept the Commission's position.
No.
And they often agree with the Commission but adopt it for themselves. But it's odd that we've got this cross-reference here. It has some weight.
Well, perhaps maybe what also be important in that context is the word as. Furthermore, as the European Commission has rightly pointed out. So they're saying this is what we've understood the Commission's argument to be. You don't have to go away and either read it in the original French or get it translated or whatever. This is what we understand the argument to be. And this is what we are adopting as our conclusion. You can't get any more from paragraph 32 by going back to the original Commission text. It's not, for example, like where they say, we accept what the Advocate General says. When you turn back a few pages and there it is. It has to be slightly different for a submission that's made by a party.
Because this isn't necessarily a public document.
It's public document.
An AG's opinion is. Yeah.
Exactly.
Very well.
I don't take a point about him using the translation. I understand why he does it. Right. So as I say, it's a hypothesis. It's the hypothesis that's offensive to Article 23. Okay. Because in practice,
I'm concerned about the time, and I'm also concerned about not cutting you short on important. But I think that we understand exactly how you explain para 32.
Yeah.
And unless you feel you want to refine that at all, I think we've got that.
Well, against that background, can I go then to GV?
Yes.
And that's going to be my final stopping point for submission. The court judgment begins at page 605. Again, you've seen it. Just again, to make the point that on the facts there's no issue, but that there was a subsisting relationship of dependency between GV and AC. AC it was, who was a Romanian national. You'll see the questions referred to, again, paragraph 30, which is at page 613. Question 1 is, I say, bang on point. Is the derived right of residence of a direct relative, in the ascending line this time, pursuant to 7.1d, conditional on the continued dependency of that relative on the worker?
So which paragraph?
So it's paragraph 30, Roman 1.
Yeah, got it. Sorry.
Is your keyword word continued?
Yes. Yes. Continue dependency.
So you make so the position is that it's a continuation of an existing dependency, not the creation of a new.
That's right. And just reviewing my notes to get you in the right place. If then you turn, they deal with the questions of my learned friends as they sort of reframe them into a single composite question, but they still look at the individual parts. That part is dealt with from paragraph 55 onwards. 55 just sets up the concept of family member. 56 deals with derived rights. 57 then refers to res. So it makes the point we've just been to. Situation of dependency must exist in the country from which the family member comes at a time when he or she applies. But then this 58, however, as the Advocate General noted in essence in point 44 of her opinion, in the case which gave rise to the case law cited in the preceding paragraph, the court had been invited to consider the conditions to be satisfied at the time when the person concerned applies for a derived right of residence in the host state, and not on the conditions to be satisfied by the person in order to retain that right. That then leads into paragraph 59, which is
just before we leave
Yes.
58. So do we need to emphasise in line 3 the words to be satisfied at the time when the person concerned applies for?
Yes. And that, of course, ties back into how you read paragraph 32 of Reyes and what was offensive there in terms of the hypothesis.
But really, the paragraph as a whole makes perfectly clear, you would say, that they are, in our language, distinguishing res,
Exactly.
because that's all they were concerned with.
Absolutely. This was a case that the court effectively picked up the point that was there and was starting to be raised.
So whatever I may say about paragraph 32, or put to you about paragraph 32, exemplifying a principle that goes beyond the facts of that particular case, that is being closed down by the court in GV. They're saying res is only about...
Completely. And at first instance, when we argued this case before Mr. Justice Lane, we had the Advocate General's opinion, so we had paragraph 44, we didn't have the judgment.
Yes, right.
So entirely rightly, he didn't put as much weight on it as he might otherwise have done for entirely understandable and contextual reasons.
We won't have to take to paragraph 44, but I mean, the essence of it is,
Yes.
we can look at that. It's clear what it says.
If the court could look at that later, then yes.
Yeah, that's fine.
That then leads you into paragraph 59. Recall that Article 14, entitled retention, provides, as it does in paragraph 2, the right of residence provided for inter alia in Article 7 thereof, as long as they meet the conditions set out in the latter article. It thus follows from Article 14, read with...
I'm very sorry, this was paragraph
I'm so sorry, I'm going over
59.
too quickly, my lord. Yes,
59.
59,
Yeah.
exactly. And then at 60, it thus follows from Article 14.2, read in combination with 2.2d, and 7.1a and d of the directive, the direct relative in the ascending line, who is a worker who's a union citizen, enjoys a derived right of residence as long as he or she remains dependent on that worker until such time as that relative, having resided lawfully for a period of 5 years, can claim the right of permanent residence. That, of course, goes back to what the judge titled his slender group, or his slender argument. Even though there is a restriction, to some extent, on the degree, the amount of work you can do if you're in the dependent cohort, even that restriction is only a temporary one, because after 5 years, you're entitled to apply for permanent residence. So you have my point already about the fact that Article 23 applies to a broad range of people, so it's still highly effective. It's still effective for this cohort, but it's also only temporary in its application to them. So such an interpretation is consistent, this is 61, with the case law of the court on beneficiary. You'll see reference to the Chenchulia decision. And then in the case at hand, not disputed that GV was dependent on her daughter, both at the time she joined and the time she applied. Therefore, at the time of that application, she satisfied the condition for benefiting as a family member from the derived right of residence. Then you get the analysis of social and tax advantages, beginning at paragraph 63, and you'll see the reference to the right of equal treatment as implemented by Article... So right of equal treatment under the treaty, implemented in Article 7.2. So far as concerns, and this may in part pick up the point my Lord made earlier, concerns the concept of social advantages, the Court made clear that includes all the advantages which, whether or not they're linked to a contract of employment, are granted to national workers generally, primarily because of their objective status as workers and so on.
Yes, I see. I'd forgotten. I asked for that note. Maybe looking at Crowfeld will be enough, but maybe it won't. So
perhaps we can review that.
Have a look. Yeah.
Then 66. Perhaps if I can just ask the Court to read 66 to 69.
Yes.
So it's dealing specifically with an Irish benefit disability allowance, which it says could constitute a social tax advantage, but a social tax advantage for the EU citizen, because it's the EU citizen who's got that right. Why is that? If one turns over the page, one looks at paragraph 71, one sees this. In that regard, it's important to emphasise that through the taxes which a migrant worker pays in the host member state in the course of his or her employment, that worker also contributes to the financing of the social policies of the member state and should consequently profit from them under the same conditions as national workers. Therefore, the objective consisting in avoiding an unreasonable financial burden on the host member state cannot justify the unequal treatment of migrant workers as compared with national workers. Well, just 4 short submissions on those passages. First of all, we say GV is directly against the appellant on the question of whether you have to demonstrate ongoing dependency. The very clear answer to that question is yes. And you've got my submissions on how that can be reconciled with para 32 of Rails. Secondly, the issue about the impact of applying for and receiving a benefit doesn't arise in A's case. So the conclusions on the second and third questions, we say, are relevant. But the reasoning, in any event, doesn't assist because it reflects the very specific equal treatment guarantee in Article 7.2 of the regulation, which is applicable only to social and tax advantages, for example, benefits which aren't at issue here. And you've got my point earlier that whatever a social and tax advantage is, it's not Article 23 access to work. Thirdly, again, I've made a submission about our present case is materially and significantly different because of the absence of a relationship of dependency. And therefore, fourthly, even
That's really the first point, though, isn't it?
Well, I put it as a first point, yes, my lord.
First and third point.
First and third, yeah. Bookend points, I think.
I mean, but the essence of it is, at the time of the application, there was no dependency.
Correct.
And that's different from the situation where, at the time of the application, there is dependency.
Exactly.
And that's really the essence of it.
It's the essence, but it's also very important because it shows you why you're then enabled to rely on his equal treatment provisions. Because there's no question but that you've got dependency, which gives you a right of residence, therefore you benefit from equal treatment and other advantages. It's my point about, you can't use the tail to wag the dog. You can't establish the right of residence by virtue of the equal treatment. That comes later. I've made my fourth point was about work not being a social tax advantage. You've got that already. Fundamentally, right to work or right to take up work, to use the exact language, is fundamentally different to a right for workers to have equal treatment in social tax advantages. It's predicated on the EU citizen's status as a worker, and the right of treatment is explained because of the worker's contribution to the social policies of the host state through the provision of taxes. That's an analysis which you can trace back in many ways to the developed jurisprudence through cases like Danner and Kreifeld, about the social interaction of workers with the host member state and the tax and other benefits system. We say for those reasons, and picking up the point the IMA makes, it's not strange, and indeed both parties make that, it's not strange at all to allow access to benefits but not to work. See the final analysis in GV. And indeed, you've got my submissions on how the EU legislators drawn the public policy line through the directive in any event. Social and tax advantages are precisely the sort of things you expect to get from paying your taxes. Well, I may just have a moment to turn my back.
Yes, of course.
I would be relieved to hear, unless there are any further questions.
No, it's always a pleasure to listen to you, Mr. Lundgren, but given the time, perhaps we're relieved.
Thank you very much.
Yes. Just one moment. Yeah. Yeah. Basically got 10 minutes. Possibly not even quite that.
The facts, we appreciate the facts of this case are complicated and possibly difficult, but that shouldn't drive the general approach to the relationship between Article 2.2 and Article 23. The fact that the claimant was 19 when she commenced work doesn't affect the analysis. When she was under 21, she obtained the right to reside. She didn't need to be dependent at that point. She then took up the right to work under Article 23, and the exercise of that Article 23 right, on my analysis, suspends the dependency requirement that would otherwise have arisen when she turned 21. So that little wrinkle doesn't affect the analysis. And then, just to make clear the point that I rose to address earlier, the judgment below, paragraph 5, simply doesn't deal with the question of whether the appellant had already ceased to be dependent through work. If I could then turn to my learned friend's submissions on the directive, Articles 12 and 13 make specific provision for specific situations, and my learned friend says yes, and there are none for Article 23. In my submission, that cuts both ways. There's no provision to say Article 23 still applies, notwithstanding the dependence requirement, but nor does it say that Article 23 doesn't apply because of the dependence requirement in Article 2.2. Articles 12 and 13 deal with, set out provisions dealing both ways with the consequences of death, departure, divorce. There's just simply nothing of that kind in relation to Article 23, and one has to interpret the relationship between Articles 2 and 23 afresh. Article 14, paragraph 2, my learned friend focused on the word conditions. Article 14.2 refers to the conditions in Article 7 that have to continue to be satisfied. Of course, the conditions being referred to are what Article 7.2 refers to as conditions, which are the conditions applicable to the union worker, not conditions applicable to the child. So that doesn't offer us any additional clue. Of course, I accept that one still needs to resolve the question of the application of the dependence requirement in Article 2. The point I'm making is that Article 14, paragraph 2 doesn't add anything to the analysis. Then in relation to Article 23, the effect of the Secretary of State submission is that the right to take up work in the case of dependent children is only the right to take up work at subsistence rates of pay. With the consequence, in light of GV, that one must remain dependent either on parents or on welfare benefits. Now, that might or might not be considered a rational legislative choice, many might think that driving children to remain dependent on social welfare benefits is not a particularly rational legislative choice.
Well, they're not children.
They're children of the union citizen.
Yes, but they might be 40 or 50.
Well, okay, forcing a person, whether they're 25 or 40,
fine, all right,
to rely on benefits rather than work.
Well, they could go home to their own countries.
Or they could go home in their own countries, or they could stay and remain dependent on benefits and work for subsistence rates of pay to top up. Now, I'm not saying that that's an irrational legislative choice. It may or may not be thought to be a rational legislative choice, but it's not the only one. And Article 23 in my submission doesn't say that this is the legislative choice that's been made. Now, to take up my Lord Justice Singh's example, the German academic with a 24-year-old child working in Heidelberg, well, that child wouldn't qualify to come to the UK because they're not a dependent, because they're working in Heidelberg.
Exactly.
If they're dependent, they could come.
Yeah, but I think that the point that the Secretary of State is making is, well, if they have been dependent in the UK, but they are no longer dependent, why in substance are they any different? Why can't they go back to Heidelberg and work there?
Yes, well, all one might ask, once they're here, having come legitimately as dependent, why would the legislature say that it's okay to compel the state to pay welfare benefits to support them, but not okay for the child to work to support themselves?
Yes. Well, I see that.
Discrimination, it's a small point, given that not much is made on the pleading issue, but it is raised at paragraph 45 of our skeleton in support of the argument. And could I just be clear about this, that I accept that one only benefits from the equal treatment right under Article 24 if one has the right of residence. Of course that's right. But the question is, what point is one talking about? Because at the point you want to take up work without losing the right to residence, it's at that point that you're relying on equal treatment rights. And at that point, you've got the right to residence. Then Reyes, paragraph 32. As I understood my learned friend, the significance of he reads paragraph 32 as saying, as the CJEU saying, that you can't exclude all work because that would cover work that doesn't result in loss of dependency, and you can't exclude that. And that's what the court is driving at paragraph 32, so the Secretary of State says. In my submission, that's clearly not what the court was saying at paragraph 32, because it was adopting the European Commission submission, which was very much not saying that, and it was adopting Le Bon by analogy. And the point in Le Bon was loss of dependency through benefits. That can only be an analogy for loss of dependency through work. Then finally, in respect of GV, if we could please just turn this one up, tab 21. And page 617. My learned friend took the court to paragraphs 57 and 58. And said that the reference to Reyes and the reference to the Advocate General's opinion means that the court was confining paragraph 32 of Reyes, the bit that I rely on. In my submission, that's not what the court there is saying. What it is doing is confining paragraphs 30 and 31 in the way that I accepted they need to be confined. And to show support for that proposition, could I please ask you to look back at what the Advocate General said in the passage that the court is referring to? And that is page 587. The court was referring to paragraph 44 of the opinion, which is at 588. But one can see that what the Advocate General in writing paragraph 44 is doing is she is responding to the submission that is recorded at paragraph 42. And if the court would please just read paragraph 42.
Yep.
That is how I had argued below paragraphs 30 and 31 of Reyes fall to be interpreted. That's what GV and the Commission submitted about paragraph 30 and 31 of Reyes. That's what the Advocate General was rejecting, and that's what the court accepted at paragraphs 57 and 58 in my submission.
Good point on which to end.
Thank you.
That is your last point?
That is my last point.
Most efficient use of your time. Thank you, or everybody. We will, of course, be reserving our decision. Due to the shortage of time, I won't spend 5 minutes telling you about all the rules which you can find in the Consul General for Wales case. We are grateful to everybody for extremely high quality submissions, and we will get you a decision as soon as we can.
Court rise is able.